Good morning, everyone. My name is Carlos Vinicius. I'm prosecutor, special advisor of the President of National Council Prosecutors, head of innovation and education of the Superior School of Union Prosecutors, and professor of administrative law here at IDP. Welcome to the webinar series Brazil and the GPA, an event of IDP and Nottingham University. Brazil formalized its intention to adhere to the Government Procurement Agreement, the GPA. We will need some change in Brazil's public procurement and contracting system. It will bring important opportunities for Brazilian big companies, especially, and the government procurement market. In this series of 10 webinars organized in partnership with Nottingham, IDP will bring some of the greatest international authorities on GPA to discuss the key issues that will challenge the Brazilian government, legislators, and experts in Brazil's entry process. I would like to thank especially Cesar Pereira and Marçal Justin Filho for the invitation to participate and moderate and collaborate with this meeting, GPA, OECD, UNCITRAL model law, Mercosul, and international standards. For me, it's a huge pleasure to stay here with you. Today we have with us three of these experts. Paulo Magina, head of public procurement unit at the OECD, Public Government Directive. Sebastian, that is an assistant professor of administrative law at the Universidade UExternado and acts as a consultant for Colombian Compra y Eficiencia, the Colombian Central Procurement Unit. Sebastian has also been a visiting scholar at the George Washington University in Paris. And we have with us Caroline Nicolas, that is a senior legal officer with the International Trade Law Division of the United Nations Office of the Legal Affairs. First of all, I give floor for the presentation. Women's always first. Caroline.
Thank you very much. Good morning to everybody. I'm going to attempt to share my slides. If there's a problem, I will then allow our technical colleagues to take over. I've had a little difficulty in doing that earlier on. Now, can you see the full size slides, or are they still too small? I can't see what you're seeing. Carlos, is everything okay, or do I need to enhance the size?
No, it's okay right now. Yeah, it's maximized. Okay.
Super. Thank you very much. Well, it's a pleasure to be talking to you, and I'd like to thank IDB and the University of Nottingham for allowing us to take part in this webinar series. I think it's exploring some fascinating issues, and in particular, the recent news about Brazil and its accession offer for joining the Agreement on Government Procurement. Now, I know that you've heard a lot more about that particular agreement recently, so I'm not going to go into details, but what I am going to talk about is the international legal framework for public procurement in the context of this opening up cross-border procurement. So I'm particularly going to look at the UNCITRAL model law on public procurement and its relevance for the GPA accession. Now, I know those of you who've been involved in these webinars previously will know this is an interactive session, so I'd welcome comments and questions as we go through, and I think you'll be aware of how to do that using the chat and so forth. To start at the beginning, if Brazil were minded, for example, to revise its entire public procurement system, because of joining the GPA or because of any other reasons, modernizing and so forth, one of the initial questions is, well, where should it start and what obligations might a country like Brazil have? Now, the first thing to say is that there's a whole list of international legal texts on public procurement here. And we have two legally binding agreements I've noted at the top. The first is the United Nations Convention Against Corruption. And almost all countries in the world are parties to that. And it has some very basic but minimum criteria that all procurement systems must reflect. And the Brazilian system, as it is, clearly does that because the principles are transparency, competition, and objectivity in decision making. And for those who are parties to the World Trade Organization's GPA, the Agreement on Government Procurement, or indeed any regional free trade agreements covering procurement, being parties to those agreements requires governments to have certain provisions, more detailed provisions in their laws. We'll look at what those are in a moment. We then have other international legal texts, some normative, some more guidance-based on public procurement. As you can see here, there's the UNCITRAL model law, there are the EU directives, the World Bank and other MDB policies, and the OECD recommendation and other guiding principles of good procurement that Paulo is going to talk about later on. And so national systems generally are based on these. And one of the things that we need to look at here is why we have all these different and all these different texts. They have slightly different contents and slightly different objectives. So as you can imagine, the UN Convention Against Corruption has very much an anti-corruption focus. The GPA has an international trade facilitation focus. The UNCITRAL model law does, but from a slightly different perspective, and we'll look at that in a moment. And the OECD is also providing more practical guidance and general principles to be implemented. And it supports that, as you'll hear, I'm sure, later, with country examples, checklists, and so on. But what is very important to stress here is that there is significant convergence on what good legal rules for public procurement should do. And the Brazilian system clearly reflects that. You have rules on transparency, you have rules on publication, you have rules on competition, and so forth. So what really is important now is the need to focus on implementation and practice, because so many countries have the essence of good procurement systems reflected in their laws. And what does that mean? Well, it means we really need to understand what these laws are designed to do. And there are two main issues in public procurement. The first is the procedure. What are we doing to try and ensure that we get good value for money in what we're procuring? And the second, which for current purposes is extremely important, is what are the government policies that are being implemented through the public procurement system? Because the more of those policies that you're trying to implement through your procurement system, and you do that simply because it's a very significant area of government expenditure and a lot of government leverage, the more complex your system is going to become. And so what all of these organizations that are putting together the legal and other texts that are on this screen, everybody is trying to improve procurement standards in practice. We're trying to improve outcomes. We're trying to improve public confidence in the system because they can see that corruption is reducing, that there are good results. Now, I'm aware all of us who work in public procurement know that it's very rare to see a good procurement story. We commonly see all sorts of scandals and nightmares, but this is the objective of what we're trying to achieve here in the context of increasingly complicated international commerce, simply because our demands are becoming more complex. So then to turn to what it is that we're trying to do with the UNCITRAL model law, both we and the World Trade Organization are trying to promote cross-border procurement. Now, in the UNCITRAL case, we have a model law. It was issued in 2011, and it's a model for national procurement legislation. And we'll look at what that means in reality a little bit later. but it's designed for your national system. It's not an international agreement, so the focus is in what a national system needs. We've been working in public procurement since the 1980s, and so we've seen the enormous developments in public procurement, moving from a clerical function to a real profession. And that's reflected in what we have in the UNCITRAL model law. It's a framework law that's supposed to set out all essential principles, rules, and procedures, but not every piece of detail. And that goes back to the point I was making a few minutes ago, that we will be needing to implement that in practice so that we have a system that's got good, not just a law that's good. And the point about it being a model is that this law is available on our website. You can download it, adapt it to your needs, and use it. And for those who are working with the GPA, we have ensured that the UNCITRAL model is compliant with the GPA's legal provisions, and the GPA, the WTO Secretariat working in public procurement recognize that. Clearly, there is a GPA committee that deals with formal compliance, but in practical terms, you can use this model to do a fitness check to see if you have complied with the legal requirements of the GPA. But because this is a model for national procurement legislation and it isn't an agreement, we don't deal with coverage issues. The schedules that Brazil would have to supply in terms of making an agreement to join the GPA are not addressed through UNCITRAL. UNCITRAL starts from the perspective that all public procurement in a system should be covered in your public procurement law, because it will be the best law that it can be if you have appropriate procedures for low value procurement, for high value procurement, for complex procurement, all following the same principles, but adapted to deal with the particular circumstances. Now, in terms of who uses the UNCITRAL model, mostly it's economies in transition and developing countries. It's used by the multilateral development banks and others donors for their own technical assistance situation. And indeed, it is being recognized as part of the country systems or alternative procurement arrangements, which is very important for borrowers from these institutions. They recognize that the procurement system that's founded on a law based on UNCITRAL will be sufficient from a legal perspective to allow the governments to use their own legal systems and their own procurement systems for the for procurement funded by these banks. Now, it's only one of a series of pillars, and I'm sure Paulo will talk about the pillars in MAPS, but it is a very important legal tool for the legal pillar of a procurement system. Now, to contrast that with the WTO, it's promoting international trade through principles of non-discrimination and most favored nation, and it deals with state-to-state relations, as well as private law transactions, and it's been going for a little bit longer than UNCITRAL. And it promotes cross-border procurement, and the cornerstone principles that you see here and the minimum standards are all slightly differently expressed, but they are the same ones that you find in the UN Convention Against Corruption and the same ones that you have in UNCITRAL. Now, we use different terminology. That's because these texts were produced in different systems, but we're getting at the same thing. And many academics, including Professor Sue Arrowsmith from Nottingham, has said many times that these rules are now, there's consensus on the contents. And I would like to say, having looked at the Brazilian laws covering public procurement, at least so far as a non-Portuguese reader can conclude from secondary sources, you have many of the provisions in UNCITRAL reflected in your law, but of course I don't know how they work in practice, and there are some differences. And certainly in terms of complying with the GPA and moving to an internationally recognized and internationally operative system, there may be some amendments needed from that perspective. And just to emphasize what I said a minute ago, that UNCITRAL's starting point for a public procurement system is to look at the national objectives. So clearly the government needs to buy what it needs, and we have the standard list of objectives for procurement systems. But I want to put a little bit of emphasis here on these other policy objectives, because that is the less, often the less focused part from the normative side. But what do governments do with their public procurement system? They want to support SMEs and national companies. They want environmental sustainability. There are social objectives looking at historically disadvantaged groups, indigenous peoples and so forth, and labour standards. And these are all reflected in the SDGs. But a lot of these things, if you think about trying to promote your national companies or trying to promote particular standards, how does that sit in terms of international competition? If technically you're going to say this procurement is available at a national level, and I know you have some provisions in your law that say that, how's that going to work when you have non-discrimination and most favoured nation type commitments under the GPA? And we're going to come to that in just a moment, but it's a very challenging area and it is a very sensitive area. And because of this, we work very closely with the WTO Secretariat. We work also with other donors, including the OECD and others, to try and provide technical assistance when countries are joining the international order, including the GPA, to make sure that the obligations that you're undertaking are clear and how you can use the template that the model law is for the more detailed needs of your national system. And we want to make sure that your national policy objectives, if you're using the model law, are appropriately reflected while you are still ensuring compliance with the international obligations in the GPA, among others. And we have a guide to enactment to the model law. The model law, I just can't show you here because I think I'm sharing my screen so you can't see it, but the model law is about 50 pages long. The guide to enactment, and enactment just means use really, is about 8 times as long. It is about 8 times as hard to make your law work properly as it is to draft it in the first place. And this is really where the emphasis needs to be. And the technical materials from the OECD, among others, are very important from this perspective. So just to summarize from the legal side very quickly, your law is broadly compliant. There are many things that are fully reflected from the model law and the GPA in there, but there are some questions about some slight differences and challenges that we need to explore. Minimum thresholds for the application of the law, the use of traditional, not electronic reverse auctions, thresholds as the basis for selecting procurement methods, and some details in your announcements. And what you can see here is these aren't key principles. These are how you implement those key principles. The key principles are reflected in your system. But one of the things that's very important to note is when you join the GPA, your legal rules must reflect the GPA commitments as well as your coverage negotiations. And so these are the areas that we work with the Secretariat to help countries with. And one big point here is margins of preference. They're provided for in the UNCITRAL model law. They're provided in the Brazilian law, but they're not allowed under the GPA. So some ways to support SMEs, domestic industry, disadvantaged groups, may conflict with these national treatment and non-discrimination rules, and margins of preference are a clear one. But also if it's just domestic procurement, that may also conflict with UNCITRAL's equivalent rules because the presumption is international participation. If you're looking at it from an UNCITRAL perspective, we would allow domestic procurement and price preferences in 3 situations. The first, that there is a legally authorized national policy or something along those lines. So there is a clear legal authorization to allow price preferences or domestic procurement. That has to be set out at least in the procurement regulations or in other laws. There are rigorous transparency provisions. It's no good burying them in the back of something that nobody's ever found. You have to say exactly how any price preferences would work in the context of a particular procurement, and you have to publicize it in advance. Absolutely. Very importantly, it's subject to your international obligations. And those include the GPA's non-discrimination rules. Now, what does the GPA say? When you're negotiating access to the GPA, you can negotiate some special and differential treatment because you're a developing country, and there would be strict transparency requirements if you apply them. That's a matter of negotiation. But if you think about what's said at the top of this screen, we're looking at generally supporting smaller domestic industry and disadvantaged groups. And what's important about that? Below threshold or non-covered procurement under the GPA can be used for that purpose. And what the GPA is trying to cover, and what UNCITRAL recognizes, is that cross-border procurement is very important for the larger and the more complex procurements. And that's where the government needs the benefit of international competition. But at the smaller end, A, international companies may be less interested, and B, this is really where you have the leverage to support development and scale up in your economies. So there is a recognition that margins of preference at this smaller level and in non-covered procurement can be used appropriately in the international system. But the real question is whether they are the best tool for the job. Now, we don't have time today to go into all of this, but it's very important to note that margins of preference in particular are subject, and also set-asides, are subject to some quite rigorous economic analysis that indicates that actually, if you want to support your SMEs, the best thing to do is to support them grow their capacity to compete effectively in the market. And that's quite a challenging thing to do. It's a huge question, and clearly it's going to become increasingly discussed in the context of economic recovery after the challenges that we have now. I'll stop there because I think there will be some questions on this, but what I wish to emphasize is the international community in the procurement sphere is working together. We have a lot of consensus on how to achieve good results in public procurement, but it isn't easy, and there are some of these questions in some areas where robust and honest debate is very much needed. So thank you very much.
Thank you, Caroline. Caroline introduces to the fundamentals of UNCITRAL model law and the concerns, which are our concerns with the anti-corruption and transparency. Now I give the floor to Professor Paulo. Paulo, you have the word.
Hello, bom dia. I hope you can hear me. Well, I will not speak in my native Portuguese. Maybe it's also difficult for you to understand it, but I will continue in English. And thank you, Caroline, for the nice references and the good setup for this presentation. I wanted to share with you, the work we are doing on public procurement standards and how we are using some assessment tools at the international level to create this playing field that Caroline was mentioning, this convergence. All international organizations, the multilateral development banks, other institutions, they have a clear understanding of the importance of procurement. And over the past 10 years, I would say that we are working closely and jointly in improving procurement standards. And I will try to explain to you how the OECD is taking part in this process. So, yes, okay. Brazil just committed to joining the GPA recently, which is very good news because we have seen in previous accession processes to the GPA how important it was, this commitment to improve the procurement system at the national level. And not just that, but I think Brazil also committed to joining the OECD, which is something very interesting to follow up in the next few years. Because, as you know, we have 37 member countries, and our economies are probably the most advanced economies in the world. And the last country to join was Colombia, And we have someone from Colombia talking after me, which is also interesting to share this experience of aligning Colombian standards with OECD standards. It's a very cumbersome and difficult process. And it happens in many different policy areas, not just procurement, but taxes, agriculture, environment, science, human resources, public administration, and so on. So when you commit the country to start a process of this kind, it will for sure change the way the legislation is done. It will change the way the laws are produced, and it will also change the way the laws are being used and implemented. And that is very important for the GPA process. We have, I know Caroline for many years now, as you know, and we have been working in different countries, improving their procurement systems and having them accessing the GPA. And we have seen how important this process is for them to adapt their national standards to international practices. And sometimes it's not an easy process. So you have challenges and difficulties in having this alignment. So I just wanted to start by telling you something that is quite clear, that procurement has a significant global impact. And you see on the screen some numbers from the OECD research and analysis. On average, we are talking about 12% of GDP in OECD countries, 1/3 of government budget, and 2/3 of this budget is spent at the subnational level. So if we think of a federal country like Brazil, the states, they have a very important role in spending procurement. And you see the share of public procurement in different public service areas. And you see the importance of procurement, for instance, for health, for education, or for defense and social protection. And this was quite visible during the recent pandemic and the recent challenges we are facing. If you go to the OECD website, we have put together very interesting reports on the way OECD economies dealt with the pandemic. And we have issued a policy paper on the initial responses to the crisis, not just on the health side, but also on the recovery phase. And you will see there the relevance of procurement for the infrastructure recovery, for for dealing with the supply chains, for improving the health response, and so on. So we are talking about a government process that is very much at the core of the public service delivery. And this is very important for us to consider when we are changing a procurement system. We are in fact affecting the way a public service is going to be delivered. And if we are making changes at the public procurement side, we need to understand how these changes will impact other areas. And Caroline already touched upon a few of the issues, how to use procurement in a strategic way, how to address and support some disadvantaged groups or some strategic policy areas, like, for instance, innovation or environment or the climate change issue. So we have been working with countries in reforming their procurement systems in multiple dimensions. We have international standards that I will talk about them in a few minutes. But we also conduct what we call peer reviews. So we go to countries that request our support, and we analyze their procurement systems in order to improve them globally, or looking at specific dimensions. And I will also talk about the work we did with a few of our countries. We also have a community of practice, the experts, the leading experts from OECD countries. They are part of our working group on procurement, and we discuss emerging topics on procurement. And we try to anticipate trends, and we try to advance frontier topics. And I will also mention some of this work in the next slides. And we are trying to bring evidence on procurement performance and impact. So on the website, you will see a lot of information, and Caroline already alluded to some of them. We try to collect case studies, and we try to understand how the procurement dimensions are moving in OECD countries. And we have very interesting reports that I can give you access to them. And finally, we are jointly, it's not just an OECD effort, it's an effort that is coming from let's say, the global public procurement community, including UNCITRAL, including the multilateral development banks, including the European Commission, which is the MAPS. So the methodology for assessing procurement systems. It's an international standard that was just revised and is now being used to assess procurement systems. And Brazil also committed to undertake an assessment of their procurement system under the MAPS. And you will see how interesting it will be, because the MAPS is, as Caroline mentioned, aligned with the different international standards. So by applying the MAPS, you will see if there is an issue with the procurement system in a country as Brazil, and if that issue will impact the accession to the GPA, for instance. So the first standard that we are using is the OECD recommendation on public procurement. It's a tool that was developed, a standard that was developed in 2015. And this standard is creating a holistic integrated approach to the strategic role of public procurement. So you see on the screen the 12 integrated principles of the OECD recommendation. And since then, we conducted more than 20 reviews of public procurement systems, both at the national level and at the subnational level, sectorial level, and so on, energy, health sector, and in OECD and non-OECD countries, because the countries asked us to apply this framework and understand how they were moving in the different principles. And on top of that, we have collected more than 180 case studies, and we also developed a checklist for countries to use in terms of implementing these recommendations. After a few years, the OECD Secretariat asked my division to understand how countries are implementing these recommendations. So in October 19, we issued a very interesting report, the progress report on implementing the OECD recommendation, that is available on our website. And this report precisely brings the challenges and the issues that countries are facing in terms of implementing these 12 principles. I just wanted to clarify that this recommendation is not mandatory. So our instruments are soft law. They are not mandatory legal binding directives. But of course, if the OECD Council decides to endorse and adopt a recommendation, it means that the recommendation needs to be followed by OECD countries. So that was the case of the OECD recommendation and of the following recommendation that I will talk to you that was just adopted. The 2020 OECD recommendation on the governance of infrastructure from July 2020. It's a very interesting recommendation because it's very timely. As you know, infrastructure will be one of the pillars for the recovery phase after the pandemic. And this recommendation has 10 principles that you can see on the screen. And these principles are precisely bringing this integrated approach to the governance and implementation and delivery of infrastructure based on the OECD experience. And I think it will be quite valuable for countries to use when thinking about their governance of infrastructure. And just yesterday, my colleagues had a meeting with the Brazilian administration because we were somehow informed that Brazil would like to conduct a review of their governance of infrastructure framework based on the OECD recommendation, which is very interesting as well. So it will be interesting to see how the Brazilian current infrastructure framework will be assessed compared to these OECD recommendation and the 10 integrated principles that we have here in order to improve the way Brazil is looking at infrastructure at the federal level. So this is just bringing to you some of the dimensions that we analyze in our reviews. So Germany, also a federal country, as you know, one of the most important OECD members. If I can rank them, all of them are important, of course, but in terms of size and economic power, they asked the OECD to conduct a review of the procurement system. And they asked us to look at the impact of procurement on the well-being. So you see a frontier topic, not very much explored before, and we managed to somehow create an indicators framework for the well-being and for linking procurement to the well-being. And we also looked at the centralization. We also looked at how to use procurement in a strategic way and how to improve the workforce. So these are some of the dimensions that now Germany is working on, and they are looking at our recommendations, and they are improving their procurement system based on the work we did. We are also working on productivity. So here, for instance, 2 OECD countries that are working with us on measuring the performance of procurement. And this is one of the issues that came from the progress report on implementing the OECD recommendation. The performance measurement frameworks are not sufficiently developed in OECD countries, so we need to work on indicator measurement. We need to work on performance measurement in order to improve and understand the impact of public procurement. So we are looking at central purchasing bodies, and we are looking at how they are impacting, affecting the economy. And we just started a similar process like this one with New Zealand, which we expect some results to happen by the end of the year. And by the way, New Zealand was one of the countries that joined the GPA recently. And the head of the procurement in New Zealand told me that the companies in New Zealand are very, very much pleased with the GPA accession. And they got much more opportunities abroad, and they understood the impact of GPA for their own competitiveness. So the final part that I would like to talk to you about is the MAPS. The MAPS is the assessment standard, as I mentioned to you. We have developed these assessment tools since 2015, together with more than 30 partners around the world, including all multilateral development banks, the Inter-American Development Bank, the World Bank, the European banks, the European Commission, the United Nations, the UNCITRAL, and the MAPS is aligned with the Sustainable Development Goals. The MAPS is aligned with the UNCITRAL Model Law. The MAPS is aligned with the WTO. The MAPS is aligned with the European directive. So by using the MAPS, you will see if there are failures or if there are issues in the procurement system. And the MAPS has, as you can see on the screen, 4 pillars, and each pillar has indicators and sub-indicators. And we developed extensive guidance in terms of applying this methodology. And we developed a very robust quality assurance mechanism that will allow different assessors to apply the methodology in different countries with the same results and the same quality. And now we are establishing a MAP secretariat at the OECD in order to guarantee this quality assurance process. And we are supporting assessments, and we conducted different MAPS assessments in many countries. Here you see some examples of countries where we are or have conducted assessments. We did that, for instance, in Kazakhstan and Norway. We did that in small islands in the Caribbean. And you see that, you know, countries with different dimensions, different development stages and maturity, they can be assessed using the MAPS. And the government of Brazil in 2018 expressed interest in applying the MAPS. And I heard from the Ministério do Planejamento that they expect the process to resume soon with the Inter-American Development Bank. And we are, nowadays, we are conducting the assessment of Greece using the MAPS in Europe. And we also did the assessment of Norway, both using the core methodology and the sustainability module, because Norway asked us to apply the MAPS to their system in order to understand how they could improve sustainability features in the public procurement. So here is the example of using the MAPS in Norway, how the MAPS is used to improve a system that was already very good. So if you think of Norway, if you think of procurement in Norway, of course, the system was very robust, had a lot of very good features, but applying the MAPS, we managed to understand strengths and weaknesses, and we managed to benchmark the Norwegian system with international good practices. And they used the results of the MAPS as an input to the white paper they submitted to the Parliament, precisely to conduct the procurement reform and to change the legal framework. And finally, this is how the maps looks like when you apply it to a certain country. You see the color code. Of course, the green are the good areas, the yellow are areas with room for improvement, and the red are areas with serious challenges, let's call it that way.
Thank you, Professor. And now I pass the floor for Professor Sebastian Cifuentes for his presentation.
Thank you very much, Carlos. So I will start with my presentation. Sorry. Yeah. So here it is. Thank you. Hi, Caroline. Hi, Paulo. I would like to talk about something which is already in the agenda of international organization, but from somehow a different perspective, and it's more of a perspective of the national domestic system, which is like the receiving end somehow of the legal transplant and the legal institutions. So how Brazil or Colombia may be impacted in their procurement system by these international standards. And as Paulo just mentioned, Colombia was recently accessed the OECD. So that has meant a lot of changes in our procurement system, but as well has showed us that changes in the procurement system, they don't always end up being what you expect them to be. In my research, I found some changes that we, like the system, made over legal institution. And it's these changes that I want to show you very briefly. So what is a legal transplant? You know, some comparatists, they say that even legal transplant, they mark the very history of law and the history of comparative law. And we can speak of legal transplant since, I don't know, the Middle Ages, when Roman law kind of revived. And also we could speak of legal transplant because of colonization. You know, Colombia or even Brazil, we belong to the continental civil law tradition because of colonization. And we stick to many of these ideas of the civil law, but also simply because prestigious institutions, they tend to travel in the world because of the prestigious. So, and public procurement law is not an exception, and is not an exception, especially for some of the things we have already seen. There are many international institutions harmonized nowadays, thankfully, that they are trying to change and shape in a good way, in a good sense, the public procurement systems of countries. And we tend to see more or less the same structure and even the same words. If you travel abroad, around Latin America, you can find pretty much the same structure of an open procedure called licitación or licitação, and then some restricted procedures that you can use under some grounds, etc., 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 and this replicates. So that shows that public procurement law is not anymore, if it was at some point, a creature of strictly domestic or national law, but is very much influenced by international organizations and ideas. However, well, this happens for several reasons that some have been mentioned today, and you probably have seen them before in the other panels you have had in these events. But more importantly, the thing is, once, for instance, soft law is introduced into a legal system, which is the case, for instance, of UNCITRAL, there isn't a review of how this law is being applied in practice. And similarly, even in enforceable international instruments like the GPA, the lack of permanent enforcement, so to speak, of these rules allow somehow to deviate from their intended ends, from their intended objective. objectives, and I call these defense mechanisms of the legal system to adapt the new legal institutions to its own traditions. It's just a word. So this happens, and this led, for instance, some scholars like Pierre Legrand to say that legal transplants are completely impossible because every single legal system is so different from each other that you cannot successfully transplant something without transforming it into something completely new. Although I don't think that this is the case, and what we see, for instance, in the whole neighborhood, so to speak, of Latin America with the procurement system shows that transplants are possible. They aren't as easy as one might think at first sight, even just as looking the law in the books and not the law in practice. It might be a bit harder to transplant institutions because the environment, as I said, always or tend to at least transform the legal institution, unless, and here there is an important thing that somehow it's happening already, you change the environment artificially or otherwise, like when you transplant plants. You can have a greenhouse and then you possibly could grow something that originally you couldn't, or hydroponic crops. And in a way, this is what happens with building capacity and these kind of things that, and the assessment of the peer review systems of the OECD. It's somehow trying to change the environment so legal institutions can work properly, and the procurement system, the law in the books, somehow will resemble more the law in the practice, or the other way around. And in this context, well, this is clear, but I just wanted to make sure I transmit this idea. I do know that transplanting institution is not the same as transplanting plants, but I think this idea of Watson is very useful for our purposes. Some disclaimers: adaptations are not necessarily bad or negative for the object as such. They might, however, deviate or undermine the purpose of the transplantations, because if the institution change so much that is not recognizable anymore, well, it's probably not achieving its objective. So the very purpose of transplantation is missed. Another important thing that relates to a question that Cesar just put in the chat, and it's what happens with management or rule mechanisms. Because procurement rules stricto sensu, understood as the award rules, they are one thing. And in Latin America, I think we all have more or less the same concerns. We kind of already learned how to use those, but our focus nowadays is changing toward the management stage. And one of the things I would like to mention is that these adaptations even happen in the management rules or mechanism. Another point is that sometimes it's hard to identify what the original rule or the original purpose was, but this can be done. And finally, I am not saying that this is completely new, because as it's been already mentioned today, international organization and even national regulators, they know that this adaptation may occur, and some of the mechanisms in place are precisely to avoid, identify, and let's say readapt institutions that has been transplanted. So in the research I've done in the case of Colombia, I found 3 different types of adaptations of procurement rules. And I will say which they are and give you one example for each of those. The first one is differing objective or differing underlying principles or assumptions can change the meaning or the purpose of a rule. And I have identified this especially in the case of Colombia, and I think this might be applicable to Brazil as well. in the case of what I call administrative law versus procurement rule and commercial approaches. In Colombia, we stick, like, public procurement law is understood as a pod of administrative law. And administrative law has a very specific ideas of the principle of legality and separation of powers, etc. But commercial approaches are hard to enter there. They don't enter as easily in this idea of very rigid administrative law. So this has created somehow a kind of not converging but opposing views of what the law is or what the law should be in the procurement area. The second type of changes or adaptations I have identified is competing legal categories. One category pre-exists in the system, a new one entered the system because of possibly international organizations' recommendations, and they clash. So one moved the other one and changed it. Okay, and finally, the third type of changes I have identified is sustained practice doesn't allow an institution to properly develop in the country and achieve its purposes. So the first example I would like to show you of these changes is when the idea is different, administrative law versus procurement, as I said. In Colombia, the framework agreements were introduced, but before that, we had a very speedy procedure, which was called minimum amount procedure. What happened was that the ground for using minimum amount procedure said that you shall use it regardless of the object. That was an authorization to use it. That was an authorization to use minimum amount regardless of what you were contracting, works, services, etc. But then it was a doubt whether you could use framework agreements and minimum amount procedure for buying off-the-shelf goods if the threshold was met to use the minimum amount procedure. Colombia Compra Eficiente, which is the central procurement unit of Colombia, issued a manual and said, yes, you can use both of them, and you shall prefer framework agreements. However, the Council of State, which is the administrative judge and also procurement judge, they say, no, you can't. You cannot use the framework agreements for below thresholds. Let's say let's use that term, for below thresholds agreements. Why? Because the law said that you shall use minimum procedures regardless of the object. So that is a clear example of reading the law strictly and grammatically in a very administrative law old-fashioned way, but certainly is very far from what procurement would have expected, which is you could use any of those and take into consideration that framework agreements, shall be preferred because you have less competition in the minimum amount procedure, you can achieve economic of scales in framework agreements, and even you can reduce transaction costs if you use framework agreements. So that was the case from 2017, which was the decision of the Council of State, till 2019, when the legislator came and readapt the institution and said, okay, you can use any of those. And the legislative branch acted as in a way to readapt the institution and bring it to the original sense, if there is such a thing. So, and I ask you, could have been prevented perhaps this change and rechange of the institution? Let's see. Another case of adaptations is competing legal categories. So a new institution enters, another pre-exists, and they clash. How this happened in Colombia, or in what example this happened in Colombia? Risk allocations versus economic balance. As you may know, well, risk allocation implies that the party that is assigned or accept the risk is supposed to bear it when it occurs. But economic balance, which is a very administrative law French idea, says that this is one of the principles and the main notion of administration of government contracts, and implies that if there is a risk, an extraordinary risk, the original equivalence of obligations and rights must be maintained. So you can see that there is more or less the same underlying idea of how to manage risk at the end of the day. What happens in Colombia was that for both categories to exist and survive, because that was what happened in the acts as well, the Council of State created some categories and says, okay, the government will bear extraordinary risks, and then when extraordinary risks occur, we will apply the economic balance theories. However, if it's an ordinary risk, it must be the contractor because he agrees to that in the contract. But it was completely unclear what an extraordinary risk was. There wasn't a definition in the law. Of course, there wasn't a definition in the contracts. And so the Council of State have to come up with an idea of what this was. For some time, this was read as being just the value of the contract plus profit. So if the risk implied that the contractor has to spend more money than what the contract was, the price of the contract, so the state will have to pay for those extraordinary risks. However, in a way that somehow undermines the purpose of risk allocation and even of a competitive procedure, because that price is not there in absentia of anything else, but it's the result of a procurement process. And if you offer that price, it's because you could have performed the contract under the conditions it was agreed. So what happened in practice is more or less this. In the common law, this is the space of impracticability or impossibility, and this is the space of risk allocation somehow. In Colombia, one possible adaptations that would have been, let's say, sensible in the way that will allow each category to play its role was this, and a space for discharge and a space for the economic balance that it was equal in the common law to impracticability, and the natural, let's say, a space of risk allocation. However, for some time, this is what happens. Economic balance end up using way more space than what impracticability or impossibility would use in common law countries. And risk allocation was reduced way more than what you would have expected when it was introduced into the country. However, there is a readaptation. Yeah, there is a readaptation of the rule, and now the Council of State understands that it cannot be just the value of the contract. It needs to be authentically extraordinary. Although there are still some cases, as this one that I showed here, where you can claim that there isn't properly a risk allocation in the sense that it's not properly allocated to the contractor. Another example of this, quickly, it has happened already in the EU, because that shows that it's not just a Colombian or a Latin American phenomenon, but what bodies of public law or governed by public law meant in the EU. Some national systems use their own approaches to those concepts, but the EU law ruled them out later on when it realizes that they were using in their own traditional sense of national law and not in the sense that EU law was expecting them to use it. Finally, practices and uses can deviate from the intended objective. In Colombia, as well, by recommendations of international organizations, standard contracts were introduced. As you know, one of the main purposes of a standard contract is to allow proper management mechanism to work in the country. They increase legal certainty, incentivize participation, possibly attract international bidders. But if you see how they work, for instance, in the UK or even in the US, standard contracts tend to have a clause that is fundamental, which is modification and termination of government contracts. This is mainly what contractors want to know when they enter into a contract or even when they enter a procurement market. So I think this explains why modification and termination clauses are so important in the UK and the US. However, when the Colombian Congress passed legislation and Colombia Compra Eficiente issued the standard tender and procurement document for works. And the clause allowing modifications and terminations, because it's very important in the rest of the world, I will show you what happened when it was introduced into the Colombian standard contract. This is what happened. This is currently the clause for modifications and terminations. It's 3 lines and read, the exceptional clauses referred to in Article 15, 16, and 17 of Fact 80 shall be understood to be incorporated into the contract. Those are the articles of the law that speak about unilateral termination and modifications, and they don't say, like the model contract, don't say anything about limits to those powers, the economic consequence of those powers, or even what the contractor shall expect when this occurs. And this is due to the practice of the country, because for several years they just tend to include this kind of clause in their contracts, and that was it. And this is exactly what happened again when the standard contracts were introduced as an institution in the contract, undermining completely the very purpose of them, because nothing is being regulated there. Finally, just a concluding remarks. First, and more importantly, management mechanisms are susceptible to be adapted, not just procurement understood as an aware procedure rules. Second, judges are very important in shaping and reshaping the adaptations, because they may create the adaptations or may reverse them when they occur. So they must be aware of the very purpose of the introduction, and this can only be understood by understanding other system, understanding the purposes of the legislator, or understanding what are the purposes of international organizations. And finally, it is for local experts to be able to identify potential adaptations, because Paulo and Caroline, they are great minds of procurement, but they can't be experts in 200 procurement systems in the world. And so it is for Brazilians to understand what are the reactions, let's call them that way, that the system may do to institutions that are newly introduced. So in this way, when you adapt a legal institution that is coming from abroad, you are able to potentially identify them and avoid them, or once they occur, you will be able to identify those and then readapt to what was intended by the legislator or the government when this happened. Just be aware of this that might happen, so you can achieve what you expect with your procurement system. Thank you very much.
Thank you, Professor Cifuentes. And when the webinar is good, we always have question and discussion. And it's the case. We have here some questions, and I would like I would ask the speakers to answer, and feel free for discuss. First question, it's from Professor Cesar, and it's all the sponsors. It's common to point out that many problems with public procurement in Brazil are related with contract administration rather than with the selection of contractors or tenders procedures. Does the UNCITRAL model law provide any guidance for improvement in government contract administrations? I think the Professor Caroline, can you help us?
Thank you. It's an extremely good question, and I wish I had a better answer, because the simple answer is no, the UNCITRAL model law does not cover this in any level of detail. Similarly, it doesn't cover the planning process in detail, and we know that the procurement cycle covers all 3 of those phases. And indeed, Transparency International considers that because we have so many good procedures and emphasis on the middle selection phase, that's starting with advertisement, finishing with the award of the contract, that those 2 other phases, and particularly contract administration, are very much more at risk these days. UNCITRAL does have a legislative guide on public-private partnerships. It's a new one. It was issued last year, which has a lot to say on management of very large infrastructure projects, not just public-private partnership ones, but generally these big infrastructure projects. But I think it's not enough. I think it's a critical area. We do note how important it is. It is a difficult area for a harmonization body like UNCITRAL to address because contract laws and processes are so different across countries. But as Paulo was saying, what the COVID pandemic is teaching us and the recovery is teaching us, these are going to be critical issues. So I'm very hopeful that when we're looking at things like how do we deal with frustrated contracts, with performance issues, with ongoing contracts that have been temporarily suspended because of the pandemic, do we have to start the whole process again? We don't have enough rules. And the OECD and others are now making recommendations on the extent of changes that you can have before you really need to start the process again. Because the one thing that is constant in big contracts is that you never get it right to start with. They always need to change. So it's a very important area, and I wish we had better guidance. So thank you for the question.
Professor, let me abuse. What's the risk of the UNCITRAL model law not decrease the risk of corruption, but turn it into a global corruption, in the sense of standardizing the parameters of corruption?
Well, I think one can always centralize corruption by making it the same, the risks and opportunities more similar. But I think it's a fair comment. But I think the reality of the UNCITRAL model is that it puts the emphasis so much on transparency throughout the process that it allows a modern system to be corruption aware, because what the UNCITRAL model does is it sets out in very significant detail all the process steps in a very transparent way. And that allows e-procurement systems, and you've got good e-procurement systems in Brazil and the region generally, to generate data. And it's that data analysis that can identify where the problems are. So that the basics, what the UNCITRAL model does is it sort of almost sets out the procurement process in terms of as process steps, so that you can have these data collection points. And Paulo is much more expert on that than I am. And in fact, we are looking with the Open Contracting Partnership at developing almost like a flow diagram or business process model, or whatever you call it. You can tell I'm a lawyer, not a management person, to facilitate this in more detail, precisely to avoid the sort of risks that you're talking about.
Okay, thank you. We have here a question. Paulo, what is the interplay between the OECD public procurement review and Brazil's need to show compliance with the GPA standards? It's a question from Cesar Pereira. It seems the OECD analysis is broader and more comprehensive than the one needed for GPA. By complying with OECD recommendations, will Brazil also be compliant with the requirement of GPA standards? Is the question.
Well, it's a very interesting question. I'm sorry that I got cut off, but that was my last slide. Sorry for that. Anyway, I would say yes, in principle, the OECD accession process is broader and it covers much more topics than just the GPA. And on the procurement, if you look at the OECD recommendation, we touch upon the 12 principles I mentioned. So by having a country being assessed for an accession process using such a broader recommendation as the OECD one, it will for sure point out some areas for improvement, and some of them were touched upon the slides that Caroline put forward in terms of the analysis in terms of competition, in terms of domestic preferences, in terms of set-asides. So these topics will for sure come up in any assessment for OECD accession, but they are also relevant for GPA. So I would say by applying OECD frameworks, of course, you will end up being GPA compliant because the OECD principles are also aligned with WTO, aligned with UNCITRAL and other international standards. So that will come naturally. If I may just come back to the contract management question, if you don't mind, I just wanted to point out that the MAPS as one of the pillars, the third pillar of the MAPS, as an indicator fully developed to procurement operations, because the international community for a long time recognized that contract management is a key issue. Contract administration, contract management is a key issue in many OECD procurement systems, and it's not fully solved. So we are putting much more emphasis on developing guidance for contract management, on improving contract management in OECD countries. And if you look at the progress report, many countries are pointing out that this is a key challenge and a key issue for them. And that's why precisely we developed the procurement operations in the new maps as a standalone indicator that will allow us to track not just the legal and institutional frameworks, but also how things are happening in real practice. So we could have a sense of the way contracts are handled and managed. Thank you. Yeah.
Thank you, Paulo. We have here a question for Sebastian. Sebastian, you mentioned adaptation of conceptions with regard to economic balance and risk allocation. How have those concepts been understood now in view of the drastic disruption caused by pandemic? Is there any discussion under Colombian law regarding the insufficient of pre-pandemic conceptions, or is that not the case?
Thank you very much, Carlos and Cesar, for the question. First, I wouldn't like to answer this as a given thing, because at the moment in Colombia we're still under lockdown and the pandemic hasn't happened yet. So this is not a permanent answer that possibly can sustain over time. However, having said, plus another thing to consider is that the decentralized aspect of procurement in Colombia doesn't allow either to give general answers to these type of questions. However, so far, as far as I know, contracts they have been able to adapt based on the rules that we already have in the past. We already had in the past rules on modifications and rules on economic balance. But the exceptional legislation issued for the purposes of the pandemic allowed modification of contracts to be over the limit that is normally permitted under ordinary legislation. So normally in Colombia, you couldn't modify a contract by more than 50% of the original value, but now you can do it for the purposes of the pandemic and because of it and then extraordinary legislation. I don't know if this will sustain over time, and we will come to answers of the type modifications were enough, rules have to be changed, and possibly not even economic balance and claims before judges were enough. But so far, this is the case in Colombia. Thank you.
We have here we have here two questions that seems like the same. Someone asks, how do UNCITRAL guides in model law on PP approach and accommodate PP rules in federal states like US, China, Nigeria, Nepal, where central, subcentral, and local legislation, may we care some differences. It's exactly the same that Caroline, you receive here in the question and answer that asked UNCITRAL and LGPA MDB maps assessment are all emerging from institutions from unitary countries. Those have several issues for implementation in federal countries like Brazil and India. Is there any experience from truly federal country in UNCITRAL model law? Can you help us, Caroline?
Thank you. It's a really interesting question. And the short answer is, what UNCITRAL tries to do is to encourage the use of the model law as a template for all systems. Now, even a state in Brazil is bigger than many countries in other parts of the world. And so the real issue is, does the UNCITRAL model law operate at all scales of procurement? Because is it designed to be used at the provincial level, at the regional level, at the local government level, at the central government level? Because then if you have everybody using the same system, it's easier to build capacity, it's easier to have trade within the country. If you want to centralize procurement of standard items, you can have one system across borders if that's what's wanted, and so forth. So the question really is the UNCITRAL model suitable for all of those systems? And as I pointed out, we don't have a minimum threshold in the UNCITRAL model. It's not like the GPA, which is looking at bigger contracts. And so we have a series of procurement methods that you don't find elsewhere, designed for lower value procurement. And so the whole system is sufficiently flexible that it can operate in different constitutional parameters, and it covers everything from the smallest to the largest procurement. So no, we don't have experience of working, for example, in 3 levels of government in a particular country. But we have discussed the use of the model law in Indonesia at both central and sub-central level. We work with the EBRD that does a lot of work at the sub-central level. I think it's Rajasthan in India that's based its state law on the UNCITRAL model, though the federal government in India hasn't. So it shouldn't be difficult to use the UNCITRAL model in that scenario. And as my fellow panelists have been saying, one of the key things is looking at not just law on the books, but law in practice. And Sebastian made this point very clearly. And it's really making sure that the law is understood and properly applied in a consistent fashion that will allow these sorts of benefits to accrue. Thank you.
Thank you very much. We're nearing the end of this webinar, and I would like to give the floor for the speakers again for a quick final considerations. And I would like to thank you one more time for the opportunity to participate with this webinar. First, Caroline for final considerations, and then Professor Paulo and Sebastian. Any considerations?
Sorry, I was muted. I think that's going to be the phrase of the year, isn't it? I think what we've learned this afternoon, I think it's been fascinating to hear a little bit more about the situation on the ground for me in Brazil and Colombia. And I think what you're hearing, I find so heartening, is that people are asking the right questions. They're asking some challenging questions. They're challenging why we do what we do at the international level and how applicable it is. Sebastian was talking about transferability. And it's really important that from those of us who work in a normative perspective, which is the easy bit, as I said, drafting the rules, work with people like the OECD, people who are doing the academic research, as Sebastian says, we can't be experts everywhere, so that we have this sort of cross fertilization of ideas. And this is in fact how the UNCITRAL model is drafted. We have worldwide experience shared both from governments and experts, and we look at things from a purely practical perspective. What's the practical problem that we've got? How do we design a policy solution? How do we implement the policy solution? And the rules are part of that. And these sorts of webinars where we talk about issues, where we share experience, I think are really important, because what we're showing here is that Brazil will need to design its own solutions that will work in its own situation. And we're offering you tools, not just rules, but tools. And then you need the capacity and the understanding to make them work in the Brazilian context and to make the Brazilian participation in the GPA and others work well for you, because you're opening up your markets to competition. You've got to make sure that your suppliers can get out there and compete elsewhere. And it's a big economic challenge. So I'd like just to thank everybody for some really interesting tools and discussions. And I hope that this is the beginning and not the end of dialogue in this area. Thank you.
Thank you, pass for Paulo. And we have here the last question, Paulo. How can countries request financial and technical support to carry out MAP's exercise of their public procurement system?
Well, I will reply to that question as part of my final remarks. There are several partners and institutions available to provide support depending on the region. In Latin America, the Inter-American Development Bank and the World Bank are, of course, key partners to work in the region. In other regions, other multilateral development banks, the European Commission, for instance, they are providing support to the MAPS exercise we are conducting in Greece. So the OECD itself, we don't have funding or financial resources allocated to work on procurement. We are not a bank, or we don't have financial support for that. We need to rely on different partners. So if you want the OECD to be involved, you need to work with other partners and ask them to involve the OECD in different projects. So coming back to the final remarks, as Caroline mentioned, I think it was interesting to understand how Brazil is moving in the right direction in terms of alignment with international standards, and how you can benefit from the work that, for instance, Colombia did in the accession process to the OECD and the GPA, and how this could serve as an indicator of the things you need to work on. I remember being in Brazil last year, and we were discussing with the European Commission the workforce, the capacity building, and the public procurement workforce in Brazil. And someone from the audience said to me, well, you end up in procurement in Brazil because you did something wrong. You did a mistake and you are punished and you end up in procurement. And I replied to them, that's not the case anymore. I think we are living amazing times in the public procurement sphere. Very unique moment, and procurement is now regarded not just as an administrative function. We are more and more seen as someone that is capable of providing strategic directions to the government and to help them developing some other policy areas that like the ones I mentioned in my presentation. So I think, events such as this one, the work that IDP is doing, the work that you guys are doing in Brazil and elsewhere, will definitely contribute to change the mindset regarding public procurement in the world. So I think I speak for Caroline and for Sebastian, of course, saying that we are more than pleased to participate in this kind of events, and I'm pleased that I interrupted my holidays, and that is one of the virtues of webinars such as this one, that I can be anywhere and I can participate in these kind of events to provide you with the view on the OECD. And we are happy to continue this dialogue in the future. So feel free to reach out to us. Feel free also to go to the website. We have our webinars. We did 3 of them during the confinement and the pandemic crisis about procurement responses to the crisis, and all of them are recorded on the website, and you can listen to them with the OECD practices. But as mentioned by Sebastian, Brazilians, they need to find their own solution. We cannot just come with solutions ready-made from other places. They might work, they might not work. We need to understand the benefits, the risks and benefits of applying these solutions, and to test them in the Brazilian context. And that's why work such as the MAPS assessment, procurement review of Brazil, and the infrastructure review that I mentioned before, this kind of work will align Brazil with the international standards and will make the country more robust in terms of their response to the challenges in the procurement sphere. Thank you. Obrigado, muito obrigado.
Thank you, obrigado, Paulo. And now the last considerations for Sebastian, and a last question also. How the shortcomings explained by Sebastian were overcome in order to allow Colombia to join a GPA?
Okay, I just want to make a clarification. I possibly made a mistake. If I said that Colombia accessed the GPA, I was meaning Colombia just accessed the OECD. But this shortcoming, as I mentioned, they have been readapted via different mechanisms as well. Some of them have been solved directly by intervention of the legislator. So that was the case of Act 1955 that bring back to its normal functioning framework agreements, whereas in other cases, for instance, the case of risk allocation versus economic balance, they were realized directly by the judges that just brought back the rules. So not even legislative intervention was needed. And this is what I meant as well at the end of my presentation by saying it is for local to identify those adaptations and bring them back if necessary to the actual intended purpose. Finally, for my final remark, I would just like to say that this is not as heartbreaking as I presented it in my presentation, because those adaptations, I have to look for them, found them, and then systematize them. But apart from them, there are loads and loads of rules coming from international organizations that do work and didn't adapt. And they are very useful and give a guidance, because as they say, you don't have to come up with the idea of the wheel every time you have to move a car. If you already have the idea of the wheel, just use it. And that was the case for many rules that I didn't show you. But I won't prevent you about the good things. I will have to possibly prevent you about the not so good. And that's it. It works, but be careful. Thank you very much.
Thank you all again. It was a pleasure to stay here with you. And one more time, I thank you for Cesar for an invitation. Thank you all.